In the vibrant tapestry of American democracy, the right to speak truth to power is not just a privilege, but a fundamental pillar. From the solemn chambers of a town hall meeting to the bustling digital squares of social media, citizens are meant to engage, question, and hold their government accountable. But what happens when those essential voices are met with resistance, when platforms are restricted, and when the very act of speaking out is deemed a disruption? Today, we embark on an in-depth investigation into New Jersey's Open Public Meetings Act, or OPMA, and the bedrock protections of the First Amendment. We'll dissect crucial court cases, translate complex legal principles into actionable knowledge, and provide a tactical guide for activists navigating the often turbulent waters of public discourse, with a close look at recent incidents in Jackson and Union City, New Jersey. Let's begin by understanding the legal framework designed to protect your participation. New Jersey's Open Public Meetings Act, commonly known as OPMA, is often called the Sunshine Law. Its core purpose, as articulated in the statute itself, is to ensure that the public has the right to be present at all meetings of public bodies and to witness in full detail all phases of the deliberation, policy formulation, and decision-making of public bodies. This isn't just about attendance, it's about active participation, allowing citizens to voice their concerns and contribute to the democratic process. Complementing OPMA is the First Amendment to the United States Constitution, a cornerstone of our liberties. It famously declares that Congress shall make no law abridging the freedom of speech or the right of the people peaceably to assemble and to petition the government for a redress of grievances. This protection extends far beyond mere polite conversation. It safeguards even speech that is critical, unpopular, or challenging to those in power. Together, OPMA and the First Amendment form a powerful shield for public engagement, ensuring that government operates in the open and that citizens can freely express themselves without fear of reprisal.
One of the most common tactics used to silence critics in public meetings is the accusation of disruption. But what truly constitutes a disruption in the eyes of the law? New Jersey courts have drawn a clear line. In cases like State v. Kane and State v. Brennan, the appellate division clarified that merely being loud, persistent, or even argumentative does not, by itself, constitute criminal disruption under NJSA 2C-33-8. The legal standard requires substantial interference with the orderly conduct of the meeting. This means your speech must actually prevent the meeting from proceeding, not just annoy or displease officials. Consider this: if you are speaking within your allotted time, even if your voice is raised or your tone is critical, you are likely protected. The courts recognize that public debate can be passionate. As an activist, this distinction is your first line of defense. If a council member or mayor attempts to silence you by declaring you out of order for simply expressing strong disagreement, you have legal ground to stand on. Here is your tactical response for the out-of-order trap. If an official says, "You are out of order, sit down," your response, calmly but firmly, "I am exercising my right to public comment under the Open Public Meetings Act. Under State v. Brennan, my speech is not a substantial disruption simply because you disagree with it. I have 2 minutes remaining." This direct citation of case law puts the onus back on the official to justify their action, often making them hesitant to escalate further without a legitimate legal basis.
Beyond general disruption, another insidious form of silencing is viewpoint discrimination. This occurs when officials allow certain types of speech, typically supportive or neutral, while suppressing speech that is critical or dissenting. The New Jersey Appellate Division unequivocally condemned this practice in Bessler v. Board of Education of West Windsor-Plainsboro. The court ruled that a public body cannot suppress criticism while allowing praise. This is often referred to as the anti-cheerleading rule, because it prevents officials from creating a public forum where only favorable opinions are permitted. This principle is vital for activists. If a public body enforces rules, such as time limits, selectively, allowing supporters to speak longer or more freely than critics, they are engaging in unconstitutional viewpoint discrimination.
This is a direct violation of your First Amendment rights. Here is your tactical response for unequal treatment. If an official says, "Your time is up," but you observed others speaking longer, your response: "I note for the record that the previous speaker was allowed to continue for 6 minutes. Under the First Amendment and Bessler v. BOE, you cannot selectively enforce time limits based on the content of the speech. I request equal time to complete my remarks." By pointing out the disparity and citing the relevant case, you highlight the potential constitutional violation and challenge the fairness of the proceedings.
Jackson, New Jersey has become a focal point for these very issues. The Township Council's implementation of a 3-minute time limit for public comments has been a source of significant contention. While time limits themselves can be permissible to manage meetings efficiently, the crucial question, as always, is how they are applied. Reports and a federal lawsuit suggest that in Jackson, these rules have been used to silence dissenting voices. In Hannum v. Jackson Township, a federal lawsuit filed in 2025, Eleanor Hannum alleged a pattern of constitutional violations at council meetings. The lawsuit specifically challenged the selective enforcement of public comment rules, particularly Section 312 of the Township Code. The core of the complaint was that the council allegedly used these rules to stifle critics while allowing supporters to speak freely, a classic example of viewpoint discrimination. The court allowed this case to proceed, signaling that even seemingly neutral rules can be unconstitutional if applied in a biased manner. Here is your tactical response for Jackson's 3-minute rule. If you are cut off precisely at 3 minutes, but have observed others, particularly those supportive of the council, speaking longer, your response: under the precedent set in Hannum v. Jackson Township, you cannot selectively enforce Section 312 of the Township Code to silence critics while allowing supporters to exceed their time. This is unconstitutional viewpoint discrimination. I demand my full allotted time and equal treatment. This case serves as a powerful reminder that the application of rules, not just the rules themselves, must be fair and impartial.
Union City, New Jersey provides another stark example of these legal battles. The case of YouTuber Leonard Filipowski, widely known as Leroy Truth, highlights the fine line between maintaining order and suppressing speech. Filipowski filed a lawsuit against Union City Mayor Brian Stack and the police department, alleging false arrest and civil rights violations at a Board of Commissioners meeting. The crux of the incident was Filipowski's refusal to speak from a designated podium. Officials claimed he was disorderly for not complying, leading to his arrest. However, Filipowski and his legal team argued that there is no law or ordinance in New Jersey requiring a speaker to use a podium. The lawsuit contends that his arrest was not for legitimate disorderly conduct, but rather an attempt to silence his investigative reporting on Mayor Stack, a classic case of officials using a minor conduct rule to suppress content. This case underscores the critical principle that rules must be reasonable and not used as a pretext for viewpoint suppression. Here is your tactical response for the podium-only rule. If an official says, "You must speak from the podium," your response: I am citing Filipowski v. Stack. There is no New Jersey statute or ordinance that requires a citizen to speak from a podium. I am speaking from the aisle to ensure my safety and accessibility, and I am not causing a substantial disruption under State v. Kane. Any attempt to remove me for this reason is a violation of my civil rights. This direct challenge, grounded in recent litigation, can be highly effective in asserting your rights and deterring unlawful actions. The First Amendment's reach extends far beyond physical meeting rooms into the vast and increasingly influential realm of social media. For years, there was ambiguity about whether a government official's personal social media page used for official communications constituted a public forum. The Supreme Court recently provided much-needed clarity in 2 landmark 2024 cases, Linkey v. Freed and O'Connor-Ratcliffe v. Garnier. The court established a 2-part test. An official's social media activity constitutes state action and is thus subject to the First Amendment
if they possess actual authority to speak on behalf of the state and purported to exercise that authority in the relevant posts. This means if a government official uses their social media to announce public meetings, discuss policy, or solicit constituent feedback, they cannot block critics or delete dissenting comments. Doing so is considered viewpoint discrimination in a public forum, a direct violation of the First Amendment. Here is your tactical response for social media blocking. If a government official blocks you from their social media page that they use for official communications, your action. First, document the blocking. Then, send a formal letter or email citing Linkey versus Freed. Your message. Your social media page functions as an official public forum under the Supreme Court's ruling in Linkey versus Freed. By blocking me for my critical comments on your official posts, you are engaging in unconstitutional viewpoint discrimination. I demand to be unblocked immediately, or I will pursue formal legal remedies. This new clarity from the Supreme Court provides a powerful tool for activists to ensure their voices are not silenced in the digital public square.
The cases we've examined today, State versus Kane, State versus Brennan, State versus Charzewski, Besler versus BOE, Hannum versus Jackson Township, Filipovsky versus Stack, and the Supreme Court's rulings in Linkey versus Freed and O'Connor-Ratcliffe versus Garnier are more than just legal precedents. They are the battlegrounds where the right to free speech is defended and reaffirmed. The incidents in Jackson and Union City serve as potent reminders that these rights are not abstract. They are constantly being tested in our local communities. For activists, understanding these laws and knowing how to tactically assert your rights is paramount. Your voice, even when critical, is essential to a healthy democracy. The Open Public Meetings Act and the First Amendment are not mere suggestions. They are the bedrock of transparent governance and free expression. Upholding these rights requires constant vigilance, informed participation, and the courage to speak out. By knowing your rights and using these legal tools, you can ensure that public forums, whether physical or digital, remain open for all voices, fostering true accountability and strengthening our democratic foundations.